Scio Farms versus Paula Clark and Anthony Clark.
We're here.
Oh,
Good morning.
There you are. Good morning. Okay, what is plaintiff's claim?
With costs, Your Honor, $3,566.99.
Okay. Mr. Clark, how are you guys going to get this paid?
So, Judge Simpson, I don't disagree that I owe rent monies, but I filed bankruptcy in October 13th, and I contacted my bankruptcy attorney, and he told me that the monies that I owed prior to bankruptcy, that I should not owe those.
She filed bankruptcy thinking her rent debt would disappear, but there's a catch. Her son is also on the lease, and his debt wasn't discharged. 6 people in that house, and the clock is ticking. Watch how she handles it.
But Miss Rachel, I don't want to butcher her last name. I'm going to call her Miss Rachel.
Okay.
She sent a message to Mr. Dodd, who was my bankruptcy attorney, that they don't feel that I should be credited those monies because my husband is not a lease holder. My son and I are the leaseholders, but my husband is listed as an occupant on the lease. So I just wanted to find out from the courts, do I get a credit for those monies or do I pay? I have no problem paying. I just need to know.
And Your Honor, if I just may respond, there was a bankruptcy, there was some email correspondence. Under the bankruptcy, Your Honor, there was a lease assumption that would potentially negate any discharge of amounts owed. But additionally, Your Honor, the bankruptcy was filed by Miss Paula Clark and her husband. The lease is with Miss Paula Clark and her son, Anthony. And so to the extent that there would have been amounts that would be discharged to Miss Paula Clark, they still remain due as to Mr. Anthony Clark as the other leaseholder. And so in short, that's why there is no adjustment to the ledger.
Okay. That actually makes sense, Miss Clark. Miss Clark, you there?
Yes, I'm here. I'm here.
Okay. That makes sense. So maybe I'm going to put it a different way. Let's say that you and your husband, for whatever reason, may not owe it. You're still, the lease, the household is still going to owe it because your son's debt, which is joint and several to that, wasn't discharged. That makes sense to you?
No, but
that's why they're not giving the credit.
Okay.
That unit is still going to owe the money. It may just be in your son's name, but they may be the same result. All right.
Okay, so we did apply for assistance through DHS. The case is pending, just waiting for the decision on the courts.
Okay, so you applied for an SER.
Yes.
All right. Did you apply for any other type of assistance?
No, sir.
Okay. So just to kind of put it all in context for you, how many people are in your household?
My son, me, my husband, our daughter, and his 2 sons.
So is that 5 or 6? That's 6.
6.
That worried when I asked you if it was 5 or 6, that worried me that you had to look up and think about it, Miss Clark. But that's all right. Okay. All right. So that you know, an SER, they typically, if you get it, they don't pay everything. So the most you get would be about 1,040 from that SER.
Okay.
Okay. All right. So there's a form that's in your packet called a rental assistance form. You'll need to fill that out and make sure that the tracking number that for your SER is on there and get that to the court by next Wednesday. Okay?
Okay.
All right. And what I'm going to do is I'm going to adjourn your case out to May 22nd, 2026 at 12 noon. That's an in-person hearing, so we'll need to see you down at the courthouse, okay?
Okay. I mean, I do have 2,000.
Okay, that was my next question. My next question is, what can you're just trying to get ahead of me, Miss Clark. That's okay. How much can you pay between now and then?
I have 2,000. I just have to go to the bank and get a cashier's check.
She already has $2,000 ready. Assistance application is pending. Judge gives her until Tuesday to pay and adjourns to May 22nd. Not out of the woods yet, but she's fighting for her family.
All right.
And I can drop it off.
What I'll indicate is you'll pay that by Tuesday, the 19th. Okay?
Okay.
And then what we'll do is hopefully maybe we'll have an answer from the SER, maybe not. But then we'll see you down here next week and we'll figure out how we're going to handle the rest. How's that sound?
That's fine. I'm sure I can come up with it.
Okay. All right. All right, Miss Clark.
So what, next Friday at what time?
Well, at 12 noon.
In person.
In person. I look forward to meeting you.
No problem. Thank you, Judge Simpson.
All right. Thank you. You have a great weekend.
You have a blessed day.
Yes, ma'am.
Deborah McDonald, 266-48168. How you doing, Ms. McDonald? Your name?
All
right, so they said they're going to allow you to plead to impeding because there was no injuries and no vehicles towed or anything. So to that charge of impeding traffic, how do you plead, responsible or not responsible?
Sorry, but I don't know what impeding traffic means.
It means 0 points and it won't go on your record. It's like a very good deal.
She's offered a clean deal, no points, nothing on her record, just $195, but she says the cop got it completely backwards. So what does she do?
Okay?
Did that cost?
It's going to cost you $195.
Great.
You what?
I will not accept it.
You don't want to do that?
I'm paying $195. It doesn't matter. Oh.
Well, then you can go to hearing on this, but and I'll be glad to set an informal. Listen very carefully. If I set it informal though, and you lose, the charge is fair to yield. That's 2 points, and that would go on your record, and your insurance rates are going to go up. Okay, if you want to take care of it today, but I don't want you to plead if you don't think you were responsible. But fair to yield. Let me see what it says. Driver failed to yield to traffic on eastbound West Road. Were you pulling out of a parking lot?
I was headed west on West Road. The other person was headed east on West Road.
At Parkwood.
Near there.
Okay.
And he turned in front of me. I did not even see him. And he saw him to the side of me. How this police officer wrote this up is the opposite of what it was.
You don't have to plead to this. If you want to have a hearing, I'll be happy to set a hearing for you. I might very well agree with you, but if I don't agree with you and I find you responsible, I just want you to be aware the conviction would go on your record in 2 points of death. Do you understand that?
I do, but I don't believe it.
That's okay.
I should have to pay $195.
Well, I mean, that's what I'm going to charge you if you're convicted here. That's per our chart. It's not something new here. So I wouldn't worry about the 195 as much as I would worry about whether or not you're going to be found responsible or not responsible. Do you understand what I'm telling you?
Yes.
It'll be a lot worse paying 195 if you're found responsible and conviction goes on your record in 2 points. But if you want a hearing, I'm all ears. I'll be glad to listen to you, ma'am.
Fine.
You think you were wrong then, don't you? Why are you coming up here and telling me you didn't think? Well, then why would you pay $195? I wouldn't pay 19 cents if I didn't think I did anything wrong.
Then I'm to go find the doctor and do it. It's not right.
Then let's set it for it. How's that? You okay with that?
To do what?
I'll set it for an informal if you want, and you can come back and explain your situation. We'll have the police officer here. But I'm just trying to tell you nicely here, if you lose, the conviction's going on your record. That's all. Do you understand that?
I do, but I'll just state it. I don't want it on the record because I wasn't involved.
So, ma'am, listen to me. I'm not trying to talk you into it. I'm not trying to talk you out of it. The only thing I'm trying to say is you can't have it both ways. You can't come in here and have a hearing and lose and say, now I'll take the impeding. You can't do that. If you truly don't believe you did anything wrong, then I'd encourage you to fight it. But if you fight it and you lose, you're going to have 2 points and the conviction's going on your record.
I'm just paid it today.
You think you did something wrong then, don't you? Then why would you just pay it today?
Because I don't want to have to, I don't know, I'm just mad about the whole thing. It just was not right. The police officer didn't hardly even speak to me. And my car was all damaged. It's $8,500 in damage. And, you know, I mean, it's still drivable, but barely.
You had insurance, though. You had collision coverage, right?
Yes,
Okay. So how much is your deductible?
$500.
Do you want me to give you time to sit down and think about this? I'll be glad to do that.
If it's gonna make it worse for me, no.
I don't know what's going to happen. I haven't heard anything here. You just told me you're going to...
I'll just pay it today and be done with it.
Why would you do that? If you don't think you did anything wrong, I don't want... Well, then let's set it for an informal.
$8,500 in damage. A cop who barely spoke to her, and a charge she says is flat out wrong. She chose to fight it. Was that the right move? Tell us what you would have done in the comments, hit that like button, and subscribe. New courtroom cases every day.
And if you change your mind, I'll talk to him about still giving the impeding. Give me a date, set it informal. Okay, Heather?
Okay, Judge, we can do the 26th at 1:15.
May 26th, ma'am, at 1:15, okay? We'll summon the officer. I'll listen to what he has to say. If you change your mind, you come back here. You remind me that they offered you impeding, and I'll still do it for you if that's what you want to do, okay?
Thank you.
All right, so go down the hall. We'll give you a notice. Good luck.
Thank you.